As regulars will know, on SQE TV, I used to be a property partner. I haven't looked at any criminal law for over 30 years, until today, because I've revised the subject of bail, which is the subject matter of the next MCQ we're going to have a look at on the SRA's sample question list. Let's see how I get on.
If you wanna be solicitors, why don't you come and visit us at SQE TV?
Just to remind you everybody, I am a property lawyer by trade and not a criminal lawyer, so in case I get this question wrong, remember I haven't looked at this subject for 30 years until I did a little bit of revision this morning. Before we attempt the question without the aid of a safety net, dare I say, what I am going to try and do is to answer it within the 1 minute 42 seconds you have on average to answer a question. What I'll do is I'll articulate my thoughts very quickly as they're going through my head, but I will undertake a more detailed analysis of the question afterwards so that you get to know why I accepted and why I rejected each answer, hopefully reaching the right conclusion. Jonny, you got this. 3, 2, 1, go. An adult man has been charged with assault occasioning actual bodily harm upon his girlfriend with whom he has a child. He has pleaded not guilty and the case has been adjourned for trial. The man has a condition of bail not to contact his girlfriend. The police receive a report from his girlfriend's mother to say that the man is at his girlfriend's flat. Naughty man! When the police attend the flat, they arrest the man on suspicion of breaching his bail condition. The man admits visiting his girlfriend at her flat. He explains that his girlfriend telephoned him and asked him to visit because their child was ill. Okay. His girlfriend has confirmed that the man's account is correct. The police allege the man is in breach of his bail condition, which the following statements best represents the position regarding the allegation that the man has breached his bail condition. A, the man is not in breach of his bail condition. Well, he is. It's pretty much strict liability because the contact was initiated by his girlfriend. Well, that's irrelevant. He will not face any consequences as a result of his visit to his girlfriend's flat. Well, actually, he could do. So, yeah, A is definitely wrong. B, the man is not in breach of his bail condition because he has a good reason to be in contact with his girlfriend. He will not face any consequences as a result. Now, again, that's wrong pretty much for the same reasons. C, the man is in breach of his bail condition. Well, we know that's wrong. He may be charged with an offence of breach of bail condition. That's wrong as well because there is no separate offence of breach of bail condition. So D, the man is in breach of his bail condition, which he is. He will be brought before the court for his bail to be reconsidered. Yep, that's definitely right. The court's got 24 hours. Actually, the police have 24 hours to bring him before the court to relook at the whole bail. And E, the man is in breach of his bail condition. He'll be remanded in custody until the case goes to trial. He's in breach of his bail condition, but he won't necessarily be remanded in custody until the case goes to trial. The magistrates could order that when the case goes to court very shortly, but that's only one of the options. And certainly he might be remanded in custody until the magistrate's hearing, but he could be released afterwards. So yeah, D is definitely the best answer.
SQE TV.
So firstly, the good news. I got the answer right. Yippee! I can actually study a subject 30 years after I last looked at it and still get the answer right. Phew, my reputation is still intact. Let's go and have a look at why we got the answer right and also see why we rejected each of the incorrect options. First of all, to say that this question covered the subject of bail and in particular what happens if a defendant breaches their bail conditions. So let's have a look at each of the options and you'll immediately see that they are written in two parts, each of them. First of all, dealing with whether or not the man's in breach of his bail condition, and secondly, some sort of explanation or statement that links to that. Let's go through option A. Well, we know to ignore the first part because that's wrong. But what about the explanation? Contact was initiated by his girlfriend. Again, that's not a good reason for negating the fact that he's in breach of his bail condition. So he's still in breach, notwithstanding that. And it's wrong to say he won't face any consequences as a result of the visit to his girlfriend's flat because, of course, the police are entitled to arrest him and put him before the magistrates for the bail to be reconsidered. So clearly that statement was incorrect. A is wrong. B is also wrong for the same reasons. The first part's wrong. The second part's wrong because the fact that he, in some senses, has a good reason to be there doesn't negate the fact that he's in breach of his bail condition. And again, he will face consequences as a result of his breach, or he certainly could do. So B is definitely wrong. C, this is an interesting one. So, sometimes catches students out this. A man is in breach of his bail condition, we know is right, but the second part, he may be charged with an offence of breach of bail condition. You'd think that there might be an offence, but there isn't. There is no separate offence of being in breach of a bail condition, so that's definitely wrong. What might happen is that he commits a separate criminal offence as a consequence of breaching the bail condition, but he won't be charged with an offence of breaching a bail condition because there is no such offence. So clearly C is wrong. So let's now have a look at option D, which of course was the right answer. The man is in breach of his bail condition, so we can tick that part. But is the next statement correct as well? He will be brought before the court for his bail to be reconsidered. Well, as we said earlier, that is definitely going to be the case. The police have 24 hours to get him before the magistrate's court for his bail to be reviewed. And then we'll see what happens. And of course, the court could decide to just keep the bail conditions in place and just give him a rap on the knuckles. And that may well be the case on the facts here because, yeah, there are mitigating reasons as to why he breached his bail conditions, although, of course, he shouldn't have done so. The other thing is that the magistrates could decide to be very, very strict. It may be that this man has a bad history of domestic violence and this is the straw that breaks the camel's back. He may be remanded in custody or given further, more onerous bail conditions. But it's down to the magistrate's discretion. That's outside the scope of the question. But clearly, this is what's going to happen when the case goes before the magistrate's court. They're going to be toying with the various options that they have. So we're looking at D being the right answer, but we need to rule out E. The man is in breach of his bail condition. We know is a correct statement. But what about the following statement? He'll be remanded in custody until the case goes to trial. Now, this is interesting because this could be the case in extreme cases. Remember, he could be remanded in custody between the arrest and the review of his bail conditions the following day. And then at that review, the magistrates could decide to remand him in custody until the trial if they feel that it's a very egregious breach. Possibly unlikely on these facts because there are mitigating reasons for the breach, but that could happen. But of course, as we mentioned earlier, that's only one option that the magistrates have, even though he might be remanded in custody overnight until the hearing if they can't get him straight before a magistrate's court on the same day. If that doesn't happen, remember the magistrates can still decide to not remand him in custody and just make his conditions more onerous or send him away with a rap on his knuckles under the same bail conditions. So clearly E wasn't as good an answer as option D. Option D was the correct answer. How did you get on?
SQE TV.
As we always do when we finish analysing one of the MCQs that the SRA has in their MCQ bank for the SQE1 exam, let us have a look at some alternative fact patterns, the what-if scenarios that you could be assessed on. So what if you got a situation where the right to bail didn't apply? Normally the right to bail does apply, but there are some exceptions. Make sure you're clear with when those exceptions apply. Secondly, be clear on the jurisdiction of the relevant court and courts that do hear bail applications. So normally it'd be the magistrate's court, but when might the case be heard and have to be heard by the Crown Court, for example, in serious cases like murder? Thirdly, make sure you're clear with the difference between the prosecution's grounds for objections and the factors that the court needs to take into account in order to determine whether those grounds for objections have actually been established. Students often confuse between the two of them, and therefore it's a really good MCQ to test whether you've really got that knowledge solid. And of course, there are the conditions that are applied in bail applications when bail is granted. Make sure you're solid with the sorts of conditions that might actually be made, and also what happens, as was covered in this MCQ, if those conditions are breached. And here is a list of the statutory provisions that you might want to revisit. Not an exhaustive list, but again, some of the main statutory provisions for you to have a look at as you go about your revision on the subject of bail.
SQE TV.
Thank you so much for watching this video. Remember, we drop our videos every week, normally one short and one long video a week, so plenty for you to get your teeth through. And if you tap the notification bell here, you'll find out as soon as our videos drop. Thank you again for watching. Remember what we always say when we finish an SQE TV video, join along with me now. We say it's now time for the jingle.
If you wanna be solicitors, why don't you come and visit us at SQE TV? SQE